This is an open video missive to the Honorable Judges Joseph A. Zayas and Rowan D. Wilson. The New York Court of Appeals, in the case of Courtroom Network Television LLC versus New York 2005, found that freedom of the press within the First Amendment must yield to the fair trial rights of those before the courts. And on that basis, New York State CVR Section 52 was found to be constitutional. They went on to say that if the legislature wanted to change the discretionary policy regarding cameras in the courtroom, it was their jurisdiction to do so. On June 14, 2020, New York State Civil Rights Law Section 79P did have just that effect. It is never reasonable to expect that a tyrant will willingly allow the incidental, independent preservation of evidence of judicial errors or misconduct when the tyrannical abuse of power can be used to prevent it. Therefore, it is necessary to bear arms against the tyranny as had happened over 800 years ago when my forefathers held the tyrant King John at Runnymede under the threat of the use of arms and was made to sign the Magna Carta, where in Clause 39 due process was born. Today, I, as among the grantors of the State of New York Constitution and the Constitution for the United States, do not ask permission to claim and exercise the right to bear the defensive arms of recording devices in the courtroom for the sake of gaining a trustee judge's permission to claim and exercise my rights, but rather to show the evidence of the nature of doing so. I do what I do to keep the corrupt judicial system from doing to my children, Rachel and Daniel, and the children that they may have, what it has done to me and my children. My goals are simple. They are to methodically and lawfully destroy the unlawful New York State prohibition against independent recording in courtrooms, to lawfully exercise my right to record court officers in the performance of their official duties in the courthouses and courtrooms of the state of New York, to lawfully produce evidence that recording in a courtroom does not constitute an act of interference with the administration of government, to show the unlawful tyrannical insanity of what occurs in the courtroom in order to prevent recording, to show that respectful civil disobedience under an unlawful mandate of the court not to record cannot result in being lawfully punished for contempt. To record courtroom proceedings under the protection of the due process rights of my clients in service to the settlement of the official court transcripts, both pursuant to New York State CPLR Section 5525 sub C, prior to judicial review, and prior to the trier of the facts deliberating on the matters before the court, for which there is no New York State CPLR statute, to preserve transcript integrity by publishing the recordings to the parties before the court or their attorneys, to openly defy any and all judicial orders which are unlawful mandates, to monetize this as a courtroom recording paralegal, as a public commentary on due process within our courts based on broadcasting appropriate segments that do not include matters of national security, identification of minors, identification of jury members, identification of witnesses to compelled to testify without a release, and the broadcasting of admissibility hearings prior to the seating of the jury. To teach how I approach civil disobedience to the general and specific prohibitions against independently recording courtroom proceedings. It was essential that I unequivocally prove that the independent person in the courtroom having independent control over the record button does not and cannot constitute interference with the administration of government. While I do greatly prefer to be conspicuous regarding such actions, that would have been detrimental to such proof, as Judge Gliedman of Brooklyn Family Court had previously and incorrectly threatened me with such a charge for quietly entering the courtroom with my client, setting up my recording equipment, and upon the opposition and his inquiry had coercively threatened me with just such a charge. I decided instead to start with the arraignment of a well-known First Amendment auditor and seek the court's permission in a procedurally correct manner that was in accordance with 22 NYC RR Section 131 and its support for transparency. For full disclosure, I knew of Sean Paul Reyes of Long Island Audit, but I had never met him, spoke with him, or had any direct or indirect contact with him before he sat next to me awaiting his arraignment on September 19, 2023. Additionally, I never heard of the Honorable Nolan Samet before he took the bench on September 19, 2023, as the judge listed was to be determined. I was among the first few people through the door when it opened. I walked to the front of the room and handed the court officer an application for audiovisual coverage that I had converted into a motion which included an argument of first impression in just 55 words. The court clerk came to me and asked whether or not I was a credentialed member of the press or media. I chose to identify myself as a member of the public. Her comments suggested that she knew how the judge would rule, but she would present it to him anyway. During the course of what was an unusually long delay for the judge to take the bench, a court officer who happened to be a high school classmate that I had not seen since 1985 took time from his busy schedule to come up and visit with me and find out what I was up to. I told him, and we had a good visit. The parade of ranking officers and his visit clued me into the idea that the judge must have sought guidance from the Office of Court Administration on how to deal with a motion the likes of which he had never seen before, and my name must once again have crossed the ears of Chief Magliano. After the delay, the Honorable Noah Samet took the bench and immediately called both the ADA and Sean Paul Reyes' attorney to a bench conference. Subsequently, notices of appearance were entered and I was called to the bench. This is both a recording from the courtroom and my transcription of what occurred.
Everyone.
So for the record, the court is in receipt of an application for audio-visual coverage relative to People versus Sean Paul Reyes, also known as Long Island Audit. We have in front of us the applicant, which is James Kelly.
Good morning, Your Honor.
For the defendant, Sean Paul Reyes. Sorry, what's your name again?
Jacob Uriel.
Uriel?
Yes.
Jacob Uriel, and Melissa Maloney on behalf of the people. Mr. Kelly, do you have anything to say in support of your application?
Yes. All of the officers present are peace officers, and under New York State Civil Rights Law Section 79P, I have the right to monitor them according to the Monitoring Act, and I would like to do so during the proceedings, specifically with respect to Sean Paul Reyes.
I'm going to take a short break here to explain that all court officers are peace officers pursuant to New York State CPL Section 2.10 sub 21. And the important statute is New York State Civil Rights Law Section 79P, recording certain activities. Civil Rights, Chapter 6, Article 7, Section 79P, recording certain activities. Definitions. For purposes of this section, the following terms shall have the following meanings. A. Officer means any peace officer, police officer, security guard, or similar official who is engaged in a law enforcement activity. Law enforcement activity. B. Law enforcement activity means any activity by an officer acting under color of the law. And C, record means to capture or attempt to capture any moving or still image, sound, or impression through the use of any recording device, camera, or any other device capable of capturing audio, moving, or still images, or by way of written notes or observations. 2. Right to record law enforcement related activities. A person not under arrest or in the custody of a law enforcement official has the right to record law enforcement activity and to maintain custody and control of that recording and of any property or instruments used by that person to record law enforcement activities, provided, however, that a person in custody or under arrest does not, by that status alone, forfeit the right to have any such recordings, property, and equipment maintained and returned to him and her or her. Nothing in this subdivision shall be construed to permit a person to engage in actions that physically interfere with law enforcement activities or otherwise constitute a crime, defined in the penal law involving obstructing governmental administration. Private right of action. 3. A claim of unlawful interference with recording law enforcement activity is established under this section when a person demonstrates that he or she exercised or attempted to exercise the right established in subdivision 2 of this section to record a law enforcement activity and an officer acted to interfere with that person's recording of a law enforcement activity, including but not limited to by I, intentionally preventing or attempting to prevent that person from recording law enforcement activity, II, threatening that person for recording a law enforcement activity, III, commanding that that person cease recording law enforcement activity when the person was nevertheless authorized under the law to record, IV, stopping, seizing, searching, ticketing, or arresting that person because that person recorded a law enforcement activity, B, unlawfully seizing property or instruments used by that person to record a law enforcement activity, unlawfully destroying or seizing a recorded image or recorded images of a law enforcement activity, copying such a recording of a law enforcement activity without consent of the person who recorded it or approval from an appropriate court. B, it shall be an affirmative defense to a civil action under subparagraphs I, and IV of paragraph A of this subdivision that at the time of such conduct by an officer, such officer had probable cause to arrest the person recording such a law enforcement activity for a crime defined in the penal law involving obstructing governmental administration. C, a person subject to unlawful interference with recording law enforcement activities, as described in this paragraph, as described in paragraph A of this subdivision, may bring an action for any violation of this section in any court of competent jurisdiction for damages, including punitive damages, for declaratory and injunctive relief, and such other remedies as the court may deem appropriate. D, in any action or proceeding brought pursuant to this section, the court may allow a prevailing plaintiff reasonable attorney's fees and expert fees as part of the costs which may be recovered. E, any action or proceeding brought pursuant to this section shall be commenced no later than 3 years after the date on which the violation of this section is committed. 4. Preservation of rights. This section shall be in addition to all rights, procedures, and remedies available under the United States Constitution, 42 United States Code Section 1983, the Constitution of the State of New York, and all other federal law, state law, law of the City of New York, or the Administrative Code of the City of New York, and all other civil remedies, including monetary damages created by statute, ordinance, regulation, or common law.
Is Is that your application?
That is my application.
Okay. Mr. Uriel, do you have any objections?
Defense has no objection.
People?
Well, the people would object to that application. First, the defendant has not established that he's a news media applicant. Assuming the court finds he is in fact a news media applicant, the people would object to the coverage being with the harm that could cause the participants. It's clear from the defendant's actions, including what has been brought to the court, that he intends to put the recording on his website and will likely name as many people as possible in an effort to have his followers subsequently harassed both on and offline. This defendant has gone to people's homes. He has gone to the police commissioner's home on more than one occasion and spoken with the police commissioner's wife. On one of his websites, or a few of his websites, I am informed by the police legal department that they have determined that on his sites he has posted, allowed posts to be posted in the comment section that indicate the names and personal addresses of the 3 DSS employees as well as the officers involved in this case. Those posts are not made by the defendant. However, they are controlled by the defendant in the sense that he could take these posts down, these comments down. He has not done so, is the information that I have been provided. This has placed the DSS employees and the police officers involved in concern for both their personal safety and the safety of their families. Should the proceedings here today be televised or streamed as the application requests, the people believe that in fact that would concern other people who are in the courtroom now, perhaps the prosecution, perhaps the judge, perhaps any other named people in connection with this case who potentially could be harassed online as well, or have people coming to their house or posting their personal information. And we don't believe that the interest of the safety of other people should be mitigated for the use of this public courtroom. People in this courtroom right now, they have the ability to observe the public proceedings, take notes about the public proceedings. We have a court stenographer who is taking down every word that is said during these proceedings, and to have this live streamed really serves no purpose other than to open up members of the court to harassment by potential followers of this defendant and or this defendant.
Respectfully, Your Honor, just for the record, I am not the defendant.
Right, I was
I'm sorry, I didn't hear you.
Just for the record, I am not the defendant.
That is
And
correct.
if I could just also clarify that Mr. Reyes is not affiliated with him at all. I know they're saying that, the defendant wants to report. This has got nothing to do with Mr. Reyes. They don't know each other. This is not an agent of the defendant. I just need to put that on the record.
Okay. Anything further, people?
No, Your Honor, rely on the record.
Okay, so the court has heard from all sides, and I understand, Mr. Kelly, your application is pursuant to Section 79P, is that correct?
Correct.
Okay, so, sir, 79P relates to the right to record law enforcement-related activities. An arraignment is not a law enforcement-related activities under the law, so your application is denied.
Thank you, Your Honor.
You're welcome.
My analysis. New York State Civil Rights Law Section 79 has the presumption of being a good and constitutional statute to be understood as plainly written. District Court Judge Nolan Samet lacks the necessary jurisdiction to strike down this statute as unconstitutional. For my purposes, my argument need not have been any longer than I made it. Had I wished to pander to the court and present a laundry list of reasons as to why I should have been allowed, I could have. But I recognized that the result was very likely predetermined by the Office of Court Administration, and the judge would not have been swayed by the most impressive of arguments. Evidence supporting this is provided later. The misstatements made by the Assistant District Attorney are both sad and comical in their inaccuracies, which speaks directly to the need to have an independent recording of the proceeding, because the court reporter is a human being capable of making mistakes. They were certified as a court reporter, an expert, for having once made less than 50 mistakes in a 5-minute test of multiple speakers speaking at a rate of 200 words per minute and they are not retested. Their expert opinion is called the official court transcript. I expect at some point Sean Paul Reyes will acquire and post the official courtroom transcript, and I believe it will be very interesting to listen to that section of this video as you read through the same section of that transcript. The court erred in that it failed to consider the least restrictive means to infringe upon my First Amendment rights. One such modification could be to redact all names, and another could be to delay the publication of the recording. Additionally, the court intentionally mischaracterized the arraignment of the defendant, which is a judicial proceeding, and completely neglected the provision of security that is quite clearly a law enforcement function in the public space of the courtroom. This was very likely at the direction of the Office of Court Administration. Finally, and predictably, the judge denied my application, which was either to grant my application to record or to explain how the court was not unlawfully violating my rights. What the court did not do was to order that no recording take place. But that matters not, because such an order is an unlawful mandate, and violating such an unlawful mandate cannot be punished by contempt, because judges are prohibited from having the power of contempt over the publication of a true, full, and fair report pursuant to New York State Judicial Law, Section 750A sub 6. The jurisprudence goes back to the impeachment of federal judge James H. Peck, 1826, the Crown versus Zenger, New York Supreme Court, 1735, and Cato's letter number 15, Saturday, February 4th, 1720. The judge's failure to state on the record a narrow, definite, and objective standard failed constitutionally again on vagueness, and the primary holding in Shuttlesworth v. City of Birmingham, Alabama, 1969 is controlling. A law subjecting the right of free expression in publicly owned places to the prior restraint of a license without narrow, objective, and definite standards is unconstitutional, and a person faced with such a law may ignore it and exercise his First Amendment rights. Shuttlesworth v. City of Birmingham, Alabama, 394 U.S. 147 at 150-151, 1969. I do expect that there are or may have been standing administrative orders from your predecessors related to prohibiting such recordings. Such orders not being freely publicly available on the website of the courts or being quickly referenced by calls to the Office of Court Administration lack the second element of substantive due process, namely notice, which is a key procedural due process element as well. As such, they are not applicable, and even if they were, they do not supersede a statutorily protected right that has not been found to be unconstitutional. The claim and exercise of a right cannot be converted into a crime. This occurred on September 19th, 2023, and at no point was I arrested and charged with one or more of the following relating to that appearance. New York State Penal Code Section 19505, interference with the administration of government. New York State Penal Code Section 240.20, disorderly conduct. New York State Penal Code Section 140.05, trespassing. New York State Penal Code Section 215.50 sub 3, criminal contempt. While it would be possible to identify New York State Penal Code Section 215 sub 3 as a correct charge against me for my actions of being blatant about my defiance of unlawful judicial mandates in this publication, no New York State judge has the statutory power to punish me for having done so pursuant to New York State Judicial Law Section 750A sub 6, sentence 2. It has been pointed out to me that recording in the courtroom is a balance of interests, and I agree. It has also been pointed out to me that my application was disingenuous in that my request to record the court officers was really an attempt to record the courtroom proceedings. And again, I agree. With respect to balance, this balances the disingenuous nature of the judge attempting to preserve fair trial rights and the substantial state interests when in fact there is the clear appearance of impropriety in that the judge, a constitutional trustee, is exercising unbridled jurisdiction through prior restraint of the independent preservation of evidence of what transpires in the courtroom by a grantor of the Constitution to prevent the incidental preservation of evidence of judicial misconduct and to evade the fiduciary responsibility of accountability. The absolute right to procedural due process includes the right to settle transcripts against actual evidence. I was not present in that capacity, in the capacity of a retained courtroom recording paralegal. This argument was unavailable to me. But the defense attorney certainly could have supported the motion on the basis of being an independent preservation of evidence upon which the transcript could be settled against. Therefore, the independent recording and publication of proceedings in the courtroom as done here is not a prosecutable criminal act, although there are legitimately times that it might be. These would include the recording of issues of national security by someone not cleared. It would also include the broadcasting of juries, minors, information about minors, compelled witnesses, and evidence of any kind before the selection of a jury. An important reason for recording courtroom proceedings is to independently preserve evidence of what transpired in the courtroom in preparation for the settlement of transcripts against actual evidence. I fully intend to educate New York State court officers to stand on their oath in this matter and to do their jobs to the best of their ability. They have been very professional, courteous, and respectful almost universally. Power tends to corrupt, and absolute power tends to corrupt absolutely. The court officers are not the major challenge with respect to the broken courts, although they may go along to get along and be reluctant to question the lawfulness of orders pursuant to the New York State Court Officers Rules and Procedures Manual, Section 1.30. In conclusion, I would be happy to meet with you in person regarding these issues at your convenience towards a resolution of the unconstitutional nature of the prohibitions against recording in New York courtrooms. I have the hearts of the people, the respect of the court officers that personally know me, the defensive arms of recording devices. I've taken your statutes, and I'm holding your court officers accountable. The only question remains is, will you accept my invitation as an echo of Runnymede in the year 1215, or will we remain at odds with each other? Sincerely, James Kelly. 631-316-5492.